and whether that came up in your research or your thinking on this issue, particularly when it comes to representation in Congress and like how the legal regime of delegates, like non-voting members of Congress, how that got established.
So I start from the premise that the U.S. Constitution is an undemocratic text. You can't vote for the president of the United States. It's illegal, actually. You can select the electoral college that then selects the president. In Congress, you have a Senate that's a quota system that gives the same power to Montana that it would give to California, with unequal representation. In the House of Representatives, the resident commissioner delegates can talk in committee but can't vote, and they only have access to one, even though in the case of Puerto Rico, they'd be entitled to 5 seats, as opposed to 1. Puerto Rico doesn't even have access to the Senate. So you have a system of representation that's bizarre. You have a Supreme Court that if the majority in the Senate says, we're not going to let you appoint somebody, there is no Supreme Court justice, or it's Harriet Miers, President Bush's secretary or a friend who gets appointed to the Supreme Court. I don't know if you remember those debates. One of the earliest appointments that Bush Jr. had was with his personal aide. He said, I want to make our Supreme Court to replace Sandra Day O'Connor. Conservatives came out and rallied. But so you have the ability to do it. Okay, in the case of districts, the idea of districts emerges in the Louisiana Purchase. And it first emerges as an effort to create a district that was differentiated from the Orleans territory. And until 1898, under the insular cases, districts and territories were treated as the same thing. There's a Supreme Court ruling called Lowborough versus Blake that essentially says that territory and the district is the same thing for all kinds of purposes. The idea of representation in Congress is beyond the scope of this conversation, but you can notice that in the case of Washington, D.C., they have a delegate. In the case of Puerto Rico, they have a resident commissioner that serves in Congress for 4 years, not 2, like the average congressional. And these are all parts of individual negotiations and legislation. And this varies depending on the territory. In the case of Mariana Islands, they had a representative because the Mariana Islands had the special international status, even though they're treated as an unincorporated territory. Today, blanking on the amendment, 22nd, I always blank. There's a specific amendment for Washington, D.C. that allows the United States to treat Washington, D.C. differently than U.S. territories, and it's anchored on that particular amendment. Washington, D.C. has 2 electoral college representatives. People can vote. Supreme Court and Bowling v. Chart established that Washington, D.C. was within the United States for the purposes of the 14th Amendment. So there have been clear statements by the court, by Congress, that Washington, D.C. is a part of the United States as opposed to unincorporated territories. Washington, D.C. is the classic, is treated like a territory before 1898. So you could say, well, why not use that precedent to treat Puerto Rico, the other territory? If we do it for Washington, D.C., why not do it for the other territories? And just as a side note, John Oliver did this take on this stuff last year. He called me, his producers called me to do something on the statehood for Puerto Rico, and I said, I gave them arguments why not even touch the subject. So they ended up doing something on voting. And they forgot to say, well, why can't we use the case of Washington, D.C. to essentially treat all territories as part of the United States? Now, there are other political implications. I certainly identify with independence of Puerto Rico, so a lot of these arguments don't make much sense to me in the first place. But I like to expose the contradictions in the legal structure and in the policies of the United States. I think it's useful to do that. So in that sense, I think before 1898, if you ask me, all territories and districts were treated the same. After the insular cases, the United States adopts a policy for the position that you can differentiate between districts and territories. But Lowborough v. Blake is a Supreme Court ruling on that subject. Yes.
So I have a couple of related questions. I think they're related. So one would be, how does race fit into this story? And the second question is, could you compare this case to the case of the Philippines, and another insular territory, unincorporated, but citizenship was never extended? So.
You're asking a complicated question. So the case of race is tricky because, on the one hand, when you look at the lawyers, judges, lawyers, Congress, they're all using this racist language to describe Puerto Rico. Puerto Ricans as 2/3 white and 1/3 black. They assumed that the Taino or Native American sort of population was non-existent. Although there are some instances where in the Mohawk Conference there's talk about looking for the Taino identity in the island. But U.S. immigration law at the time allowed Latinos to be treated as white and allowed people of African heritage to acquire citizenship for immigration purposes. So in that sense, the question of race in Puerto Rico, the sort of Anglo-American, Anglo-Saxon notion of we're colonized uncivilized person, comes into clash with U.S. immigration law. Now, the Supreme Court, in a ruling called Intre Giralde, in this particular ruling, which you can't see, unequivocally established, a federal court in Maryland unequivocally established that Puerto Ricans were declared whites for immigration naturalization purposes in Gonzales v. Williams in 1904. And if you send me an email, I'll send you the opinion. And that's the language, you know. The Supreme Court established in 1904 in Gonzales v. Williams that non-alien immigrants are racially eligible to become U.S. citizens. But again, you have the courts operating in their own way, you have Congress using a different rhetoric, and you have the president and policymakers adopting all kinds of racist arguments. If I were to say, if I were to look at the question of race in a bigger scheme, when I look at the double standards that are applied for Puerto Ricans and the residents of other territories, I could say that there was a racialization of the territory in a way that you don't see in other territories. And my social, if you will, explanation is that the colonialist model allowed for white settlers to colonize particular territories and organize them into states. In the case of Puerto Rico, there are too many people living there. So white settlers never quite took to settling Puerto Rico or colonizing the island in order to make it a state. If white settlers would have migrated to Puerto Rico in the same way that they migrated to Hawaii, and in Hawaii they've been migrating since the 1820s, missionaries in particular, I think we would be talking about a different statehood colonial sort of project. So in a sense, the unincorporated territory is a racial project. It's a gender project also. It's part of gender dynamics that Laura Briggs has studied, I think, in interesting ways. But it's also part of a contradiction, because you have Congress and courts and individual actors just using all kinds of racial narratives that were inconsistent with immigration and naturalization laws at the time. So that's as close as I can get to the racial argument. I mean, there are other racial arguments that I can look at individual cases where you see people talking about applying the Southern Reconstruction model to govern Puerto Rico and the territories, people using the Native American sort of project to govern Puerto Rico. But these are individual sort of projects that occur in particular writings of lawmakers. In the case of the Philippines, it's tricky. And the reason for that is that the residents of insular areas, including the Philippines, under the 1906 law and the 1914 law, were allowed to become U.S. citizens. There are Filipinos who become U.S. citizens because the U.S. needed to govern the Philippines. The case of Philippines, I stray away a little bit because Philippines became an independent country and was always waged in a war, unlike Puerto Rico. The Philippines was always waged in a war. So the policies that were adopted for the Philippines were responding in some ways to the rebellion that was occurring, how we declared war. That was first with Aguinaldo and later with other folks. And you can see that in the Jones Act of 1917. And here, Jose Cabranes, which I disagree completely with in many things, I think has a point. The U.S. decided to punish the Filipinos with the version of the Jones Act in 1916 because they were considered to be disloyal. Whereas Puerto Ricans were rewarded in some ways with the Jones Act because they were considered to be loyal. I think that's a simplistic analysis, but it captures the difference between Philippines and Puerto Rico. I think it's simplistic because in 1906, Puerto Ricans were allowed, and Filipinos were allowed to become citizens. Now, it is, I'm blanking on the ruling right now, but it is true that the Supreme Court essentially establishes that U.S. can strip U.S. citizens of Filipino heritage of their citizenship. There is, I'm blanking on the ruling right now, but if you send me an email, I'll send it to you. McGovney has a discussion of that. Linked to that would be a racialist argument that's tricky, which is really, I think, there were some policymakers saw the Philippines as an extension of China, and they sort of saw, in a racial sense, the Filipinos as sort of Chinese within the logic of the Chinese Exclusion Acts. Some policymakers. Again, the Philippines is a much more complicated case. I think the question of rebellion is really the salient issue. There were fighting wars against U.S. invading forces. But I stray away from it because by the 1930s, U.S. was recognizing already the independence, or was starting to recognize the independence of the Philippines. In the case of Puerto Rico, the presidents that were established in 1901 continued. So the presidents of the Philippines sort of departed. Yes?
Charles, I have two questions. The first one is that in the 1930s, especially the second half, was a period of intense political militancy by the pro-independence movement in Puerto Rico. It was also a period of intense repression by the American military forces. At the end of that decade, the establishment political parties, Partido Liberal, Partido Socialista, the party that defended statehood basically collapsed, and a new political party emerged and won the elections. That new political party, Democratic Popular Party, was identified originally with independence as a solution to the status of Puerto Rico. So my question is whether in the congressional record there are some references to that instability in Puerto Rico to justify the 1940 law that you are presenting. The second question is more interesting to me, and it is the reality that no sector in Puerto Rico, especially pro statehood, has ever claimed that Puerto Ricans have a birthright to American citizenship. Quite the contrary, they have been using fear-mongering, alleging that without statehood, Puerto Ricans are always exposed to losing the American citizenship. So my question is, how could you explain that statehood people, or statehood people in Puerto Rico, has not noticed that explicit interpretation that you are offering us? And secondly, could you find explicit declaration in the law and in the congressional record saying that about the right citizenship?
Okay, so let me start with the first one, which is an easy one. Santiago Iglesias Pantino, the Rose Resident Commission, kept pushing the idea of the 14th Amendment being extended to Puerto Rico. And in fact, the 1934 amendment to the Jones Act, he claims, and the record suggests he's right, was an effort to do that, was an effort to introduce the first notion of birthright citizenship in Puerto Rico. I think it's an incorrect reading because the status of the territory is not changed in the 1934 amendment. It would only be changed in 1940, or at least there's no declaration that Puerto Rico is in the United States until 1940, for citizenship purposes only. Now, I have been trying to figure out why all of a sudden Congress and the President are interested in granting birthright citizenship to Puerto Rico in 1940. They didn't have to, other than this being an administrative problem that every couple of years they have to fix. And that's what the congressional record suggests, that this is mostly an administrative headache for Congress. I have been looking for some sort of military justification because we're entering World War I, because of the nationalist uprising, because of the labor. I have not found any evidence that any of those social movements had anything to do with this. But I'm hoping I can find it somewhere because I suspect that would be the most logical argument. I just haven't found it in the congressional record or the debates, even in the Bureau of Insular Affairs military records of the period. There's no evidence that, because they understood that granting citizenship was not the same as granting statehood in their logic. In the U.S., when you read all the historical record, there is no vision of statehood for Puerto Rico ever. That's just been a local Puerto Rican political party argument. It's not in the military, not in Congress, and I've looked at every legislation, status legislation, since 1898, more than 120 bills, and there are some statehood bills, but there's no indication that Congress is interested in granting Puerto Rico statehood. And right now, just to clarify the record, if Puerto Rico, based on electoral data, if Puerto Rico became a state, Congress would have to reapportion 5 seats to Puerto Rico in the lower house and 2 in the Senate, and they'll all be Democrats. So Republicans are going to give 7 seats to the Democratic Party. That's just math. I mean, that's, if you look at electoral data in Puerto Rico, Puerto Ricans vote 2-1 when they vote in primaries for a Democratic candidate over a Republican candidate. And most elites in Puerto Rico identify with the Democratic Party. The question of the statehood party, I have never understood that argument other than for the reasons that you suggest, that this is how they sustain the political party by creating this ambiguity, this anxiety among its members. So I would argue that there are three possible explanations. One is a strategic political argument that the statehood party just wants to fuel itself, legitimate itself in a political situation that's untenable for them. Because even though Congress has not said they're not going to grant statehood, anybody who can read nothing and can read anything in Congress knows that statehood is an impossibility for Puerto Rico, because you would have to balance the Senate and the House, and that would mean granting statehood to Washington, D.C., which would be another Democratic state. So it's a dead debate in Washington, D.C. But in order for fundraisers to make money, I think they use that argument. Second, to be honest, this story that I'm telling you, nobody's written about it, except Chris Boswell, Trias Monjes, and Jose Julian Alvarez Gonzalez. This is not part of a story that we're told. I mean, even these immigration documents, I've never met anybody who can explain to me, except maybe one person, Samuel Letterman. But he didn't know anything after 1917. And the third argument, the third response, I think, on why Puerto Ricans have not used it is because of the Congressional Research Service Memorandum of 1989 that has taken over public debates. Academics buy into this. Academics, I mean well-known academics, the president and Congress. They say Puerto Ricans are statutory citizens. Even though this is a memorandum, this does not address the question of the 1940-52 debates. Does that make sense?
Still, that doesn't explain why people in the 1940s, 1950s, people especially who were participating in the Constitutional Convention for the so-called Puerto Rican Commonwealth, and people who defend the statehood participated in that experiment. That doesn't explain why they missed that particular law granting birthright citizenship to Puerto Rico.
Yeah, no, I don't know. Beyond those three, I really don't know, because I've had conversations with pro-stateholders, and I've had nasty conversations with pro-stateholders where I argue this, and they look at me like, I've never heard of this. So the general anecdotal response that I get is, I've never heard of this. I mentioned it to Pierre Luisi's office a couple of years ago, and they sort of looked at me with a blank face. I've never heard of 1940 yet. Now, again, to your point more closely, David Efron, who's a pro-statehood lawyer, when he goes to sue in Florida to enable his daughter to naturalize, and the idea is that once she's naturalized, she will become a constitutional citizen through Article 1, Section 8, Clause 4, and therefore can't lose her citizenship if Puerto Rico becomes independent. When you look at the ruling, the court says, we were governed by the 1940 Nationality Act. So the court establishes unequivocally that the 1940 law is the source of law. Now, when you look at the 1989 memo by the CRS, the source of law of citizenship for Puerto Ricans is the Jones Act. So you say, well, the Congressional Research Service in 1989 is still arguing that the Jones Act is the legal basis for citizenship. And these are the best paid researchers in Congress. They corrected that argument in a status debate plebiscite report after Jose Julian Alvarez Gonzalez made his case. But even Jose Julian Alvarez Gonzalez is arguing that the 1940 law is a naturalization law, not a birthright citizenship law. I mean, he suggests that there's a birthright component to that, but he treats it as a form of naturalized birthright, which is an academic argument that was posed a couple of years ago. It doesn't make any sense. So beyond those three, I don't know. I don't know how to answer that question because it doesn't make any sense to me. But even Roger Smith refuses to look at this law.
Time for maybe one more quick question, and then we should. Gloria, do you agree with me? Where is she?
There.
Here.
Sí, una pregunta más.
Okay. One more. One or two.
I'll leave you one. Why Ted Cruz is not a citizen? Because of this. So in 1989, the Congressional Research Service said Puerto Ricans are statutory citizens because they're born outside of the United States. And they use a 1971 ruling called Rogers versus Belay, which establishes that any person born or naturalized outside of the United States, any person born or naturalized to mixed parents, one citizen and one alien or foreigner, cannot claim a 14th Amendment citizenship and therefore is not a constitutional citizen. So it's based on an affirmation of the Immigration Nationality Act of 1952. So Rogers versus Belay has been used to say that Puerto Ricans are statutory citizens because they're born outside of the United States for constitutional purposes and therefore can't claim a constitutional status. Now you can apply that to Ted Cruz because his mother was a U.S. citizen and his father, it's not clear whether he was Cuban or Canadian at the time, was the child of a mixed marriage. And Ted Cruz was born in December 22, 1970, and the Supreme Court ruled on April 28, 1971. So that law specifically applies to the child of mixed marriages. In the case of Ted Cruz, his citizenship was conditional upon a residency requirement. A residency requirement meaning that any child of mixed marriages has to establish a 5-year residency in the United States between the ages of 14 and 28. So Ted Cruz, in order to retain his U.S. citizenship, according to Rogers versus Lilly, had to be a resident. Now that element was abolished in 1978, so it's kind of mute. But the law at the time of his birth treated him as an alien citizen, conditional on birth. And again, going back to why Puerto Rico is important.
But he is an alien, everyone knows that. Not in the green sense of the word.
He's a naturalized citizen. He's not,
In the green sense of the word.
if you follow the 89 memo, he's a naturalized citizen. But sometimes I don't disagree.
What they say about him is this issue of natural born
So the Constitution.
citizen.
So the Constitution has two types of citizenship. You either naturalize, Article 1, Section 8, Clause 4, or your birthright citizenship. First sentence of the 14th Amendment. There are no other citizenships in the U.S. Constitution. So the question is, what is blood right or derivative forms of citizenship? If one or two of your parents is a citizen and you're born outside, you acquire a blood right citizenship. The 1971 ruling says that the children of mixed marriages, one alien and one citizen, has to go through a naturalization process.
And that doesn't make them a naturally born.
That doesn't, they're naturalized citizens. Now, there are other debates that are broader, whether the
I
child
can't
of
be
two
president
citizens.
either, if that matters to anyone.
Yeah, I mean, it's not going anywhere. I think I'm one or two people who are saying this.
He was born in the 70s.
All right, any other questions? I'll be around. I'm at UConn. Feel free to send me an email.
Thank you so much.